So welcome everybody to the Global Network for Human Rights and the Environment and the United Nations Environment Programme's second annual Summer Winter School on Human Rights and the Environment. This year, our theme is Water from Oceans to Taps. And we are extremely excited about this morning's very important lecture because I think it kind of goes in many ways to the heart of many of the issues we've been thinking about and talking about throughout the school. It looks at human rights, climate change, and the whole water cycle, and points us to the reasons why climate response requires a human rights perspective that incorporates a whole water cycle approach. And I'm very happy to have Dr. Marlene Pevia here. She's a lawyer and an independent researcher in the field of international law, environmental law, international human rights law, and climate change law. Her work is interdisciplinary and multidisciplinary, and she's looking at the intersection of rights of nature, human rights, and climate change, and its potential to advance global climate change action. Without taking up any more time, over to you, Marlene.
Thank you very much, Dina. Good morning, good afternoon, good evening, everyone. I am really glad to be here in this summer winter school organized by the Global Network on Human Rights and the Environment and the United Nations for the Environment. It is a really honor to be here. And I will start with my presentation, which actually touches upon many of the topics that have been already touched during the previous sessions throughout this week. So I would like to open the room to have more reflections about all these concepts that we have been discussing throughout the week. The human rights in the human rights implications of the human right to water or climate change or the ocean acidification. So many different concepts that we have been discussing throughout the week that come together and inform us about real problems and real action, real challenges that need to be addressed. The governments in civil society as a whole. So I will share my screen now. And I think it's this one. Yes. So I would like to, first to address some initial concepts on climate change. I think that my computer case a bit funny, doesn't obey. 1 second, please. It seems that doesn't click on it while I am in the video. So I will try without, so I can go further throughout the presentation.
Do you want to send the slides to me and I can share them?
Yes, I can send them. Let me see. Once now it's working better. Yes. So the Intergovernmental Panel on Climate Change, the IPCC, which is the United Nations intergovernmental office that formed by a pool of scientists that address different aspects of climate change and give data on the impacts of climate change throughout the world, and they are appointed by the governments, and is actually the highest authority in climate science. They warn that the world is coming to us only about a decade to reduce global emissions in such a way to hold global temperature rises below 1.5 degrees Celsius. in order to avoid dangerous climate change effects. Specifically, the report states that the lower the emissions in 2030, the lower the challenge in limiting global warming to 1.5 degrees Celsius after 2030, with no or limited overshoot. The challenges from delayed actions to reduce greenhouse emissions include the risk of cost escalation, locking carbon-emitting infrastructure, stranded assets, and reduced flexibility in future response options in the medium to long term. This reminds us that we have less than a decade to address with far-reaching and radical responses to climate change. And this includes taking governments governments measures like they did for the COVID-19 pandemic, measures of that time to address the problem of climate change, to radically drop the levels of emissions. However, governments in most part of the world have failed to take significant action to address this problem, and this the worst implication of this delay or this passive attitude of many governments throughout the processes, for example, in the context of the United Nations Framework Convention on Climate Change, has led to harm of the environment and of the human rights of people throughout the world. It has been previously said, climate change affects adversely a number of human rights, not only in the global south, but also the world. Specifically, the rights most affected by climate change are the right to life, the right to food, the right to health, and the right to adequate housing, to culture, the right of indigenous peoples, of children, of vulnerable groups like the rights of women, or people with disabilities, migrants, and of course the right to water and sanitation. These measures the measures that are taken by governments to address climate change, like mitigation and adaptation measures, have to also take into consideration that these rights are not affected by climate change. However, there have been repeated practices where the measures meant to tackle climate change have harmed the populations, local populations and communities, especially the most vulnerable in societies. This is, we can say that this is the paradox of climate change. Those who are at the forefront of climate impacts are those most vulnerable within societies, and those who bear the most severe consequences of climate change are those most vulnerable in society. Climate change is the problem, one of the problems of climate change as a global challenge to be addressed, is that one of the narratives that have been used throughout decades in global discussions about this problem is that it's a problem of the future, that is something that will happen at some point in the future, but not really addressed like a problem that needs urgent action. An imminent problem, already happening problem that is taking its consequences now by people, especially those in most extreme climate situations. For example, one of the first to raise voices with regarding the effects of climate change in their local environment, where the Inuit population in the Arctic region, they in 2005 made a petition to the International Inter-American Commission on Human Rights, asking to claiming that the emissions of the carbon dioxide of the United States were harming the permafrost of their local environment. They producing higher temperatures that were reducing the ice in the area of the Arctic where they live, which was affecting directly their households, their means of living, their culture. Also, this petition was not taken, but by at that time in 2005 by the Inter-American Commission of Human Rights. This was a big initial step, a milestone step to raise the voices about the effects of climate change that started to be felt in the Arctic. But as usual, as part of human nature, when something doesn't happen in front of one side, perhaps it's more difficult to take action immediately. Then in the future, more and more cases started to point out to the effects of climate change in the rights of people, especially in the global south. Even cases of climate litigation were not were not a common use resource in the global south, a difference of litigation, climate litigation happening in the US or in some countries in Europe, like in the United Kingdom or initially in Switzerland. But later, like several years later, in 2015, we had one of the most recognized or famous renamed cases in climate litigation. That was the Urgenda case raised. Was a case Urgenda, a Dutch NGO, filed a claim against the Dutch government in the court of The Hague, to claiming that the Dutch government was not doing enough climate action to reduce its greenhouse emissions. Of course, the defense say that climate change was a global problem, and being a global problem, they couldn't do nothing to drop, or well, nothing. It's a way to say, but basically it was not their fault because it was a global problem. Climate change. However, the Dutch court, was of the view that indeed the Urgenda was on the right side, and ordered the global the Dutch government to take actions in the coming years to drop its emissions. This claim, of course, escalated, but this initial view was confirmed. Aside the technical legal aspects of Urgenda, that this is not the topic of this presentation, that this would need a whole discussion, but in general, this presents us how climate change impacts upon human rights have been raised by civil society through climate litigation at local level, and that is making an impact on government's policies, which in a situation of business as usual, or if nothing is done, probably this action wouldn't have been taken. So it is important in that sense to to highlight the role of civil society on taking action to protect the rights of people through different means, including climate litigation, human rights-based climate litigation. One other aspect of climate change that delays or contributes to delay action is that it's next to being from the future, is that in the context of human rights, non-actual people or people not existing in the present generates questions of who is able to claim on behalf of future generations. For example, when we want to protect the rights, including the right to water and sanitation. The water that we use or misuse in the present will affect directly the rights of young and future generations. However, this raises several human rights issues that can generate problems and give room for delay in action. In this respect is precisely civil society, with a number of mobilizations throughout the world, have been able to address the issue of human rights in the environment and the crucial role of young people, of children, and not yet born generations that will have to bear the consequences of the no action today. So, another problem of the climate change is that it's always it's a problem that is indiscriminate. It touches upon everyone, not only in a particular region of the world. Of course, there are some areas more affected, but it touches to everyone. So that is an issue that needs immediate action, but it generates delays in government actions. Is indiscriminate, and being a problem of everyone becomes often a problem of no one. So that is one of the reasons why there is delay, and also it needs urgent action. However, no, this is not done. I would like to pass on to the part of human rights. I wanted to point out to a renamed article of Christopher Stone, "Should the trees have standing?" In a climate changing world, it is crucial to interrogate our relationship with the natural world and how this is portrayed in the laws that govern us, including human rights. Christopher Stone, at the time in the 70s, already pointed out to the need to rethink and to be imaginative with rights, that we cannot stick to one single idea that we, the human beings, are the only ones capable of having rights. And this doesn't mean that we have to give rights to all the elements of nature as we know with the term of rights precisely. But we can understand we can start thinking broadly about rights and about our relationship with the natural world. He said the natural objects have traditionally been regarded by the common law and even by all, but the most recent legislation, as objects for man to conquer and master and use. Indeed, we have been entitled by law to exploit and in many cases plunder the natural environment, and as we in the belief that we as human beings are the masters of nature, and it is an object for us to exploit, and we are the subject and superior, hierarchically superior to exploit it and its elements. And in that sense, the law picks up on this premise and reflects in our law, in our international laws, this understanding, this wrong understanding of human rights, which, giving its neoliberal birth and conception, it picks up on these beliefs, and somehow it's important we also look at human rights critically. And of course, while they are in a crucial element to address climate change and to address the right to water, to protect the most vulnerable in the world, at the same time, we have to be conscious that human rights has important limitations, and it has conceptual assumptions or misunderstandings that will need to evolve throughout the time. In particularly, the climate change, the context of climate change provides a scenario that can trigger a evolution or development of human rights law, in the sense to look differently nature, to look nature not as an external object, but start feeling the humans as part of this environment, as one species like others, which share a common home. This is something that at some point, hopefully with the development, among others, from other sources, also from climate litigation, this can be developed in the coming years in a way that we start understanding and seeing nature in a different way. For example, Christopher Stone, in his reflections, said there was a time when we saw, or slavery was common, was normal, was even allowed by laws, but now no one would accept that as a law or as a allowed practice. However, we have evolved as a global society, and we know that is not admittable at this point. In the same sense, there would be probably at some point a society more evolved that would understand nature differently, even from a rights perspective, which is entirely or eminently anthropocentric and dedicated to the protection of the human rights. Having touched upon the human rights aspect, I just wanted to give some reflections on the human rights part and the conceptual understandings inherited in the human rights, in order to be aware, to have a critical approach from human rights to the protection of the human rights to water and sanitation, and also to the whole water cycle. Indeed, in this week, there have been discussions on the right to water and the different elements that are part of it. We have talked about what implies to have and to the right to water. It should be available, accessible. It should be of quality. It should have quality and safety. Another element is affordability, acceptability, privacy, and dignity. Is not correct the view that it should be for free. It could be for free, yes, but having passed a process of treatment through different processes, if it costs something, that's the point. Anyways, the point is that if it should be that the price, whatever it is, should be affordable to the population. As we said, and it has been already discussed, it should be available and accessible. However, we have seen that many places of the world, particularly in the global south, the effects of climate change that exacerbate the rights already affected by communities in the world affect particularly the rights of the most vulnerable. For example, women are particularly affected when the right to water, the right to water is particularly affected by climate change. For example, due to droughts, women have to go more kilometers, more distance to gather some water for domestic use, and they have to manage at home the use of water, and this can be a source of gender issues, and also they are affected by illnesses because of lack of accessibility or less accessibility to water resources in the area where they live. Although this has been these elements of the right to water have been pointed out by the report in the report of the special reporter on the human rights to safe drinking water and sanitation. The right to water doesn't appear in any international treaty. It doesn't have explicit reference in, for example, in the international covenants, nor in the main treaties. However, it has some implicit references in the Convention Against Discrimination of Women, in the Convention of the Rights of the Child, in the Convention to Persons with Disabilities. Despite that the right to water has been protected under international human rights law through these references and through the clarification in the general comment of the International Committee on Social and Cultural Rights, Economic, Social and Cultural Rights. The right to water is the most affected by climate change, and also by the dangerous use of water resources, especially in coastal areas where there are several local populations, as we have been talking during the week of small-scale fisheries. These populations have been particularly affected by the lack of water resources and the lack of participation in processes that involve their living, their culture, their means of livelihoods. One of these populations affected by impediments of the right to water, particularly because of lack of action from the government, has been the coastal population in Peru. This is there was an oil spill in Peru in this year in January. Tons of oil were spilled into the Pacific Ocean by the company Repsol, and they affected more than 700 hectares in the coast of Peru, affecting fisheries in the area, affecting the ecosystems. Birds and fishes in this area were not found anymore, and were found in these conditions. In many times, many people just them there and couldn't save them. And also the contamination of water, the works of decontamination of water continues, because it was said that it was not, it couldn't be this the water affected couldn't be this problem could be solved in many years. However, this case still didn't help for the government to take more severe action and more severe regulation, stricter regulations to address the behavior and the protocols of the companies that work in this area, which in many cases pass slightly or very easy or questionable environmental impact assessment protocols, and these are the consequences of that. So I want to reflect in this context on what could be our approach to. Oh, sorry, the video has stopped. 1 second. What could be our approach to nature? I would like to raise some thoughts about how would be our approach to nature in the context of climate change, if this would help, and this if we start rethinking about how we could be we could prioritize not only our activities in taking into account environmental consequences of our daily activities, our consumption, our food in our daily life, how we will start relating in a different way with nature. I would like to stop for some time here to open this for some conversation and discussion, because these reflections are important to observe and to start rethinking and reimagining law, including human rights and the rights to water, to understand why in the first place we came to this situation of climate change, where life is not, where life in general of humanity and non-human beings is under threat, and we are probably facing a time of climate collapse, and we need to take serious action and start looking at nature in a different way. And this includes the oceans, the rivers, and all the elements of the environment. If someone wants to share a view on these reflections of this initial thought of nature vis-a-vis humans, how we can see nature. There have been mute? No. There have been, like in the case of Peru, there have been several cases in that in the same that have several cases of harming the natural environment in different countries. So having a lot of experts who have spoken about the rights to water and the rights to sanitation, I would like to see to explore or to discuss how this could be, how this situation can help us to rethink the human rights and the approach to the water. Anyone wants to share a thought? Yes. Kathleen?
You're muted, Kathleen.
Yeah, of course I am. Isn't technology fun? I thank you so much for your presentation in the first instance. Secondly, I was wondering if, given the wide-reaching and holistic nature of these issues, and given your incredibly, wonderfully diverse background in your research, if you had any feeling on what is maybe the most or one of the most effective ways of getting movement, like actual movement on these issues, and for lack of a more nuanced way of saying this, getting people in more privileged settings to care about things that happen, like the situation in Peru. Thank you.
Yes, thank you, Kathleen, for your intervention. This is a great question. I think so far, meaningful climate action has been taken basically or mostly because of bottom-up pressures, because civil society has mobilized to take action, climate action, and putting pressure on governments to do something. And as I said in the beginning, it has been throughout, in many cases, through climate litigation. But these cases, even if they are not successful in the courts, if they don't receive a favorable decision, still they have an impact in civil society, and they give visibility to the actual human rights stories behind the problems, behind their claims. Normally, it's like a Goliath and David fight, because these corporations normally have they have a lot of resources, and they can put pressure on governments. And for example, in the case of Peru, Repsol claimed that they were conducting their processes, and this oil spill was due to external factors beyond their hands, because there was a tsunami in Tonga in the other side of the Pacific coast, and it affects the carry out of their activities, which later was demonstrated that it wasn't, but these investigations are still ongoing. However, as it has been pointed out previously, the local populations are the most affected. These people are fishermen from the coast, and these people only depends of their fisheries, of what they do every day for the food of each day. So whatever you take from the sea, you say the fishes, you sell them in the local market, and then you get the food for your family for that day. That is the situation. So when these people suddenly lost all their livelihoods, the means of subsistence in the coast of Peru, they had a critical problem, and there were no even an authority to accommodate their demands, at least in the first days, as an urgent issue, because it was clearly a human rights issue. These people they couldn't provide the food, the water, the sanitation for their families, because many of them live in precarious conditions in those areas. So I think that basically the visibility of these cases through climate litigation and through all these or through climate action at local level, I think could be in many cases the strongest to achieve climate action, meaningful climate action. And it has been pointed out, and it's clear that governments need to put more severe regulations to corporations operating in their country to protect the environment and to protect the local communities. It is well known that governments are under pressure. They have a conflict of interest, to say it in a way, because they have to protect the local population. They are obliged to protect their rights, but at the same time, they should also, or they should generate investments, or they want to attract investments, foreign investments, for which they have or they agree upon contracts that are not beneficial in most of the cases for the local populations.
Thanks for that question, Kathleen, and thanks for that response, Malena. There's a question in the chat that I think adds to this conversation, but also comes back to your point about, I think, taking a sort of critical position on human rights. From Christiana. In your view, can we say that climate change questions the idea of progression and expansion of human rights over time, promoting instead an idea of persistence of existing level of enjoyment of fundamental rights would be better for planetary health?
Can you just repeat the last part, please, Dina?
Would promoting instead an idea of persistence of an existing level of enjoyment of fundamental rights, rather than focusing on the kind of expansion and growth of human rights, would that be better for planetary health?
I believe that climate change helps to catalyze the development of human rights. It's too early to say how exactly it may help to trigger human rights development. But as I pointed out first, climate litigation, human rights-based climate litigation, showing that human rights have the potential to help to put the human faces at the core of the problem of climate change, that these stories are real stories in the climate effects of climate change are for real. They are not science in a book, but they are happening in daily life for people around the world. However, the consequences is that even if those cases are not accepted or endorsed by courts or tribunals throughout the world, still it raises attention, it raises awareness of the impacts of climate change on human rights, and that help to expand our understanding of human rights and how we interrelate with nature, which I think is at the core of the problem or the critique to human rights. We continue, and not only human rights, but actually the body of law, international law, international frameworks legitimize the idea that humans are the subject to conquer or to use the natural resources as a sort of raw material for them to enjoy, to capitalize, to profit, and not something to care about, no interrelate with respect and with respect to the environment and to respect to other non-human entities, non-human beings. And this is something that I think with time may expand in human rights. The rights of nature, it's even if it's a different body of legislation, somehow interrelates with human rights in that aspect. For example, the rights of indigenous peoples, it's clear that they have the ancient knowledge on human rights. The ancient knowledge of interrelation with nature, that and they are considered the guardians of many areas of the world, and legislation has been passed on in many, not many, but in several countries already there is legislation protecting for a river, for example, in New Zealand, now in Colombia, there is a forest that recently has been given the rights. So personhood, legal personhood before international law. And this, according to an advisory opinion from the International Court of Human Rights, Inter-American Court of Human Rights. So it is also in Canada, in the US, there are some legislation to protect elements of the environment. So this, and this is just a sort of a premonition with no research on it, but I think that this the trend is that this will continue growing, and human rights itself will help to highlight those the need to interrelate different with nature, like vis-a-vis, like to feel as human beings part of nature, not separated, not hierarchically superior, or not as a superior entity, an object in the nature object for human beings to exploit. That's going to change, I believe, but probably in decades from now.
Thanks very much, Elena. I think that's a really fascinating discussion. Thanks for the question. I think partially the answer goes to kind of what we understand by expand versus sort of quite radically reinterpret and re-understand what rights are and how we keep engaging with rights and what they are. Are there any others? Sorry, go ahead.
Yeah, I just wanted to point out a very little point on this. This is important. I believe that we not only reconsider our understanding of nature from our international law, including international human rights law perspective, which, as we know, has been conceived in a neoliberal, it has a neoliberal conception, which somehow legitimates the use of nature to satisfy human needs. But it is also important that we start interrelating, not only in that we are conscious that this evolution is not part of law. Law will be only a reflection of this new understanding for us, but the new relationship with nature start with us, with action. The law is something that later reflects those changes in society, but first these changes starts with us. And there are many examples in history how a society has changed their understandings, or, for example, as I said, on slavery. And this will take time for law to reflect, but it will be upon us to start changing independently. If we see later the right of a river or the new right of a forest, it doesn't matter the title that they give it, but it's our relationship with nature which may start changing from now with this climate and environmental concerns.
Thanks very much for that. I wonder if I could ask you to say something more about the kind of whole water cycle approach.
Yes.
Because I think that's really important and interesting, and maybe a big gap in the law. It sort of thinks about fresh water or drinking water or sanitation or oceans, or, you know, there's a real separation of water. So I was wondering if you could maybe expand on
Sure.
that a little bit?
Sure. Having made these reflections on the right to water, more like from a philosophical standing point, regarding to the human rights to the human right to water and the human right to in the context of climate change, with sanitation, as we have said, is still an underdeveloped topic, but it comes and is attached and interlinked and interdependent with the right to water, as well as we know with other rights. And the right, the assumption is that the right to water is when we talk about the right to water, we tend to think that is something that comes from the tap. That is the water that I am entitled to have, the water that I can use for my daily use for human consumption. But there is where there is a disconnection with the whole process that it takes for the water to get there, the chemical, the technical processes that the water goes through to make it available and apt for human consumption. And in that process of making the water apt for human consumption is what links water with the water that we have in, let's say, in its raw state, like in glaciers, in oceans, in rivers, in lagoons. That is the disconnection that we probably make with, or is generally understood about water. Like water, if I cannot live without water, but we think in the water, in fresh water that we or water that we have for daily use for our purposes, but in this connection of the whole process that it has passed through, and in this connection with its natural and original sources. And here is where when it comes the relevance of keeping safe or stop the pollution in the oceans, in the rivers, because that is the water that is needed in the case of the oceans for fisheries, for other activities in the rivers, for fresh water, but this water to be treated by in the dams or to go through the process to make it up for consumption. And this is what this is the gap that there is in between the water associated as a human resources or as a natural resource when we see it in the natural environment in the form of different in the different form that we can see water in the environment, and the water that that we use at home or that it's available for human consumption, and that is associated with the right to water and sanitation. And having this gap may present additional challenges because it disassociates, as it has been pointed out here, it disassociates the problem of keeping in the scarcity of water throughout the world, but also the pollution of the sources of water, which are very limited because the water most available is the water from the oceans, but only a tiny percentage is the water that we can use for human consumption, that we can treat and use for human consumption. And I would like to finish this part and open the floor for questions with this talk of Murray Bookchin, known as the father of social ecology. It says, in this confluence of social and ecological crisis, we can no longer afford to be unimaginative. we can no longer afford to do without utopian thinking. So the biggest changes come from utopic ideas. So I would leave it there. Thank you for listening to me, and sorry for a bit accidental presentation. I have been a bit sick the last few days, so I am a bit with my voice not at 100%. But thank you very much. The floor is open for questions.
Thank you, Marlena, for that really fantastic lecture, and for being here and persevering despite being a little under the weather. We really appreciate it. There are a couple of questions in the chat. The first one says, thank you for the presentation, Marlena. This change of society that you talk about from anthropocentric approach to ecocentric would change the human rights law, as we will talk about human obligations towards nature and the environment, and not only various rights to use the environment. So it's more of a comment. Is that your sense of it as well, that that the evolution is a shift to a kind of obligations approach?
I think while we keep our modern state organization in human rights heavily or entirely relies on the states for the fulfillment of human rights, it's difficult to see it in a different way than that states' obligations towards rights holders on human rights, including the human right to water. However, what I would, even though the human rights framework in general and human rights rhetoric is eminently anthropocentric, it's the area of law dedicated to the human being to protect the rights of humans, and was born in the aftermath of the world wars. So in developing that context, still the leaning or balancing or going somehow to an ecocentric approach to rights, I think can be envisaged, but not like a dichotomy, not like or anthropocentric or ecocentric human rights. But the anthropocentric approach of human rights could be in a scenario of evolution, could be graduated in a way that we interrelate, or human rights interrelate differently to nature, that see it in a different way, especially when we talk, for example, when we take into account particular rights and knowledges like the rights of indigenous peoples in the world that have a different connection with nature and with law. Their laws incorporate the respect and you in a different relationship with nature. So probably life or climate change may be one of the external factors that force us to reimagine human rights in that direction.
Thanks for that. We have another comment that I think it would be interesting to hear you comment on as well. Kathleen says, I wonder if the way current legal structures create silos is also a problem. People ask me what kind of lawyer I am, but doing housing law has meant knowing about my client's health, access to daycare, dance classes, food allergies, and public transit access. I think this is a really important comment, and one that's kind of come up a lot in the school is the problem of siloing kind of across the law. So we have bodies of trade law, and then of environmental law, and then but then also within those areas of law, as Kathleen points out, we sort of think about discrete rights. And I wonder if rethinking nature, which is kind of all encompassing in very important ways, also encourages a rethinking of this sort of siloed way of legislating and regulating. Kathleen, I might be totally distorting the point of your question, but I'm adding a piece.
No, that is exactly what I was ultimately getting at, and just kind of an addendum to that is one of the things that I think is so amazing, Marlena, is when Dina was introducing you, the scope and diversity of your research and your writings and your interests, climate, human rights. It's really amazing. But part of me as as an individual is how do I take myself out of the silo? How do I start to get involved with lawyering for the environment, for human rights, as well as housing and the ocean and women, etc.?
For this very interesting question, and actually very timely question in these times of climate change and changing environment, where we have to respond with not only with policies but with actual action in our daily life. And this has been the problem of climate change, of the climate change law framework since its beginning. Only no more than 1 decade ago, climate change was seen as a highly and technical issue, only addressed by science, by scientifics, and who through the reports give the information to policymakers to develop this framework. But the human rights implications of climate change were absolutely out of the conversation of the climate debates. They were restricted to technical, to science, climate science people. And this has changed really recently. And it's amazing now how climate litigation has, it's like coming out more and more in different parts of the world, in different contexts. The rights of, the rights of generations and the rights of indigenous people. So it is important that we see human rights always, as I think someone pointed out in previous discussions, as an interconnected, interrelated field, because all the rights are complementarily and interlinked. However, the process of negotiation of the Paris Agreement itself is a proof that we can break those silos, that having such difficult such a difficult negotiation process that led the world to the adoption of the Paris Agreement by the United Nations Convention of Climate Change. It was adopted, and scientists and lawyers and policymakers came together to bring these areas. And climate change is a cross-cutting issue. It touches upon all aspects of life, economics, trade. So we really have to think out of the box and to break silos by seeing ourselves and our disciplines as coming together towards a common objective of overcoming these unprecedented challenges. I hope it somehow gave some ideas to your question.
You definitely did. Thank you. And it just on that final note, the quote you shared at the end reminded me of my first day of my class on romantics literature. in my undergrad degree, my professor looked around and asked who among us were interested in going into politics and law, and a bunch of us stuck up our hands. And he said, good, because I would hate to think I was teaching you this for nothing, and then proceeding to spend the semester learning about poetry, about Wordsworth, Coleridge, and all the English romantics. So that it just reminds me of that and how important imagination is. So thank you.
Yes, and actually, just picking on that point, I would suggest reading Murray Bookchin, who has a completely different view or approach to climate change or the environment, and brings up really new perspectives, even if though they could be discussed or contended, but it's still the bottom line is to think out of the box, to propose new understandings of law, rights in society, and how we manage ourselves. And so far, we see that our approach to human rights, and particularly to the right to water, which is so sensitive to states, and which is reflected by the no mention of the right to water in this in treaties, in human rights treaties. It's like the covenants is tell us how we can start thinking about human rights and the right to water, and address these issues from a human rights perspective.
Thank you.
Thank you.
Thank you both. We have another question in the chat. In your view, how do you see the right to water and water rights? Some people argue that both of these terms are the same. So water rights versus right to water, I think, is the question. Some people argue that both of these terms are the same as two sides of a single coin. For instance, in cases of international water bodies, this question is raised many times. Are there any international instruments which gives classification for those terms?
I think, in principle, the rights to water or water rights mean or are associated as part of the same human rights to water and sanitation. And since these have been addressed in UN documents and declarations, and is increasingly recognized and used, I think it could be addressed as the human right to sanitation, or pointed out as human right to sanitation, even though the part of sanitation is still underdeveloped, and still needs much progress and implementation, of course, around the world.
Did you, I don't know if I did your question justice, but so did you want to add anything to that?
Sorry, Dina, can you repeat, please?
I think this question came from Bayisa Lemasa, and I was just asking if you wanted to add anything to the discussion.
Thank you. Thank you. I understand. Thank you.
Okay, excellent. Thank you. We have a comment about imagination. It says, look at drinkable rivers. I think this point about imagination is a really kind of moving and important one in lots of ways, and it's also something that's come through in a lot of Indigenous scholarship and writing recently about not just the importance about sort of not being sort of unimaginative, but opening sort of human rights law, international law, domestic law to Indigenous imaginings that have been kind of excluded from the ways in which we engage and think about the world. So I think this sort of this idea of being imaginative, of reimagining, of sort of thinking about the imagination in the space of law is sort of very important at this point, and draws on lots of, and could draw on lots of different sort of traditions of thought, as Kathleen said, you know, thinking about poetry and the romantics, but also sort of thinking about other worldviews, and sort of coming to recognize the limits of our imaginations in legal regulation.
Exactly. I think the indigenous people's law wonderfully addresses these gaps in several instances. For example, in the relationship with nature and with the elements of nature, of seeing ourselves as guardians, as trustees of the commons or of nature, and not the masters of them. And interrelate the fact that we don't talk, or they don't have rights, as we call them. It doesn't mean that we are entitled. We are entitled because our rights, our system of rights as a human species, we can use them and exploit and plunder natural environment for our own interests or benefits. I think mainstream law in human rights have a lot to learn, or to incorporate, or to expand from the indigenous people's rights, and also from other views. We should keep in mind that human rights is basically a creation of in the Western world. It has been inherited or conceived in the Western world according to certain values, which are now universal, and is fine. Is the most is the lingua franca of the world. Is the universal language. That's fine. We don't have to reinvent the wheel, but we have to look at them critically, I believe, and not pushing forward finito thing, but a finalized concept or finalized narrative, but something evolving and that can be improved and even correct specifically on its conceptions and assumptions and understandings of the human relationship with nature.
Thank you. Thanks for that, Marlena. Kathleen's made another point in the chat, which links to a presentation we had on gender and water, I think on Tuesday. So Kathleen said, thinking of poetry and law and the need to include multiple perspectives, the same professor showed us images of original drafts by male and female poets. The men wrote several with many, many edits, the women far less so. And my professor pointed out the simple fact that even middle-class women in Regency England had too many domestic tasks to write more than one draft due to the overarching gender norms of the time. And it made me think about a presentation we had a couple of days ago on the women and on the gender and water panel. One of the panelists just talked about the experience women have of time poverty and the way water plays into that. So just the sort of hours women spend collecting water, waiting at water pumps, traveling back and forth, and how time poverty not only limits their sort of capacity to engage in other activities, to be with their children, to engage in income generating activities, to engage in, you know, things that aren't just the sort of drudge of moving water back and forth, but how it also kind of limits their political participation, and limits their just emotional space in a way to sort of think and be, which I think is what Kathleen points to here as well. And I think that relationship between water and time has been a fascinating theme that's emerged in the panels. And I think it does connect to your point here about imagination in a really important way too.
Yes, yes, I think it was in a panel from yesterday that we went through the history of the right to water. Even if we didn't think about the right to water as a right in the beginning of the times, even there were already sensitivities about water and intentions or manifestations of property rights or securitization of water. And so water is part of human beings. We are water too. So this issue will last until the human species lives in this planet. So I think we are just upon a point in time where we are discussing about how we will address water in the future, and perhaps the climate change may help to rush us, to prompt us to think differently about water and to preserve and to don't see the water as the thing that I need that comes from the tap for my daily use and benefit, but also as water in its natural state, and then to care of to care and protect and maintain clean the ocean, the river, the oceans, the rivers, the lacunas, the glaciers, and realizing the importance for our existence.
Absolutely, thank you. I see Banya has sent a really interesting resource talking about law and art, made me think about an interesting project, drawing the law in the Anthropocene. That looks really fascinating. Thank you for sharing that resource. Just to say that our chats have been really rich and interesting. We are saving them, and we are going to find a way to share the resources that have been shared in the chats there, because I think that they've been they've almost been a parallel summer school has been happening in the chats. I don't see any more questions. It's been a fantastic conversation. Thank you to all of you.
I think Baita just raised his hand.
Yes, sorry, was there a hand?
Baisa? Sorry.
Maybe just a thoughtful fist. Marlena, before I close the session, I just wanted to hand over to you to make any last remarks or comments before we stop.
Yes, thank you. I really would like to thank to UNEP and GNHRE for this opportunity to address this wonderful audience and have it put together so in a wonderful way, so interesting, insightful, fascinating conversations, panels, presentations that give us the opportunity to be that civil society that wants action mobilizing, that needs mobilizing in order to get more from governments and from those who are in the position to make more radical actions. But these conversations help raise awareness of the importance of water, of thinking of water not only as a resource, but also the importance of water in connection to the oceans, to the problem of ocean acidification and all the issues that arise with water. And also thank you to the audience and thank you for the patience, because I've been having my throat didn't help. Thank you. Have a wonderful rest of the day for all of you.
so much. Thank you for that fascinating lecture. It was really fantastic, both to get sort of some background and overview, but also in many ways a kind of really critical call to action in some ways, to rethinking, to reimagining, to re-being in a human rights whole water cycle approach. Thinking through climate change through those frames is so important. Thank you for your participation today. Thank you for the fantastic conversation with the audience today. It's been really fascinating. Don't go away. We have 2 more lectures left in our summer school. It's been such a big week. I can't believe we're sort of coming to the end of it. The next one by Larissa Basso is on water for clean energy transitions, which in some ways brings together these themes of climate change and water and the tensions between them. So it sort of continues this conversation in a way, but with a big focus on the idea of clean energy. So come back to that. That's in half an hour. I'm going to post the link in the chat. As I said at the beginning, this lecture was recorded. It'll be on our website. So come back and listen again. Marlene, thank you for bringing this incredibly important perspective and engagement with the critical themes of this summer school. It's felt like a good lecture to have on the Friday as a kind of bookend, because in many ways what you've talked about has spanned the kind of entire theme of the school, and that's been incredibly interesting, but also sort of opened us up to new ways of thinking. See you all, I hope, at the next one.
Thank you. Bye-bye.